Hi, my name is Natalia Willett and I'm a real estate attorney here in the state of Florida. And today I wanted to talk to you about when you acquire property at a foreclosure sale, are you automatically a landlord? Well, that depends, of course, on who is in the property. So if you purchase the property at foreclosure and the debtor is a person that's in possession, you can request that they leave immediately. They do not have rights either under federal law or state law to stay in there. But let's say the person announces themselves as a tenant and they either show you a lease or let you know that they have an oral month-to-month tenancy in place. So in the event that this is not a mortgage foreclosure, so I'm going to talk about condo association foreclosures, homeowners association foreclosures, and private lender foreclosures. That means lenders who are not subject to the Federal Tenancy at Foreclosure Act, because that only affects Fannie Mae, Freddie Mac style mortgages that are regulated by federal law. So in the event that you have somebody that notifies themselves like that, Florida Statutes Chapter 83.561 tells you that you have to post a notice of termination of tenancy. And that notice of termination says that they have 30 days in which to vacate the property, that during that 30-day period, they do have to pay rent, and you put in there what amount of rent they will be paying. Of course, that will generally be the same rent that they tell you that they were paying under their oral lease or whatever rent is on their written lease if they had a written lease. But in the event that they do not pay that rent, you can always move to petition for writ of possession, say, hey, they didn't pay rent, please, judge, kick them out now because they're not bona fide tenants. So that's part of the issue that I've discussed before in other videos. Are they bona fide tenants? That means, do they pay market rent or somewhere around market rent? Are they not related to the prior owners, prior debtors? And then, of course, to be a bona fide tenant, you actually have to pay rent. So big thing to consider there. But what I wanted to talk to you about was, what are the obligations that you have as a quasi landlord to these people? And so you are subject to Chapter 83.67 of the Florida Statutes. And 83.67 says that while you do not have all of the other responsibilities and encumbrances involved in being a landlord, you do have to do the following. You cannot prevent their access to the property. You cannot cut off utility access to the property. You cannot discriminate against service members. You cannot prevent them from putting up a U.S. flag prominently, within reason on the property. That's not something that can be prevented. And so generally you have to think about those factors when you are acting as a quasi landlord to the people for the next 30 days or so. If you violate any of those things, you can be liable for 3 months rent or actual damages, whichever is higher. So be very careful. Please pay attention to 83.67 of the Florida Statutes. Study it, learn it, especially if you are investing heavily in HOA and condo association foreclosures. Good luck out there, investors.